Welcome to Time is Not on Your Side with your host, board-certified litigation attorney Robert Eckard. In every episode, we'll hear from other attorneys, accountants, and other professionals who can impact the success of your litigation. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Now here's the host of Time is Not on Your Side, Rob Eckard.
Hello, everybody, and welcome to another podcast of Time is Not on Your Side. I'm your host, Robert Eckard. We're going to be talking about court-appointed receivers and the role that receivers have in private and government litigation, both state and federal, and their involvement in litigation in the courtroom. And today we have a very seasoned lawyer and a guy that the feds often call when they need a expert receiver in their cases. Our guest today is attorney Mark Bernet, a shareholder at Akerman Law in Tampa. And Mark has a very impressive background. He's a 1986 graduate of Notre Dame College of Law. He's always ranked as one of the best lawyers in America, and he has vast experience in commercial litigation in cases in both state and federal courts in the areas of finance, banking, securities, real estate, aviation, and the hospitality industry. I've known Mark for, I think, going on almost 20 years or more, and his experience conducting fraud investigations, tracing assets, identifying fraudulent transfers is something he's very good at. In today's episode, we're going to have Mark hopefully answer some questions that we have about receiverships, the different types of receiverships, the nuanced issues of being a receiver, take some of the mystery out of what it is to be a receiver, what his job entails, how receivers get appointed, the lifespan of a receiver and some of the things that happen during the receivership estate. And if we have time to touch upon the differences between a receiver and a monitor. And what he likes about being a receiver, maybe what he doesn't like about being a receiver. So from there, we'll take it away. Mark, good afternoon.
Hey, Rob. Good to talk to you today.
Thanks for being here today. So if you will, Mark, will you, given your experience as a court-appointed receiver, first, what are the different types of receiverships?
Yeah, that's a good question, because people hear the word receiver and they don't understand that it actually entails a number of different kinds of receiverships. Probably the most common is what I call a property receiver. Now, the property receiver is what you see a lot of times in mortgage foreclosure actions or other real property actions where there's a dispute about the property of some sort. Those typically are geared toward preserving the value of the property and avoiding waste. So if a receiver is appointed, it's typically because the owner of the property has not been maintaining it properly. That includes, among other things, collecting rents or revenues from the property, but not paying it to like a lien holder, a bank, because that's the bank's collateral more often than not. If the money is being wasted and not being put back into the property, if taxes aren't being paid, if we aren't maintaining the property, these are the kinds of things that a court looks at. And if that's what's going on, then court is inclined sometimes to appoint a receiver to just take over management of the case. It doesn't really affect the underlying litigation because they're just kind of a placeholder to keep the property under control. There's also what I call a business receiver. Now, these are similar to a property receiver, except that instead of taking over a property, the receiver will take over a company. And usually it's for the same kinds of issues. The company is not being operated properly, or sometimes the issue is the company is deadlocked. Folks love to, and here's a practice pointer for all the attorneys, do not create a company that's got 50-50 ownership. you are just cruising and asking for a deadlock when the partners, if you will, disagree about something.
Mark, in your experience, when that happens and a litigant is asking a court to appoint someone like yourself as a receiver in a business receivership, you come in and the partners or the shareholders are in a deadlock. What do you do in that case?
Duck. Usually they're fighting with each other. The judge,
and this could be any type of business, right? It could be a manufacturing business. It could be making widgets. It could be making computers.
It could be a sales company. It could be anything. If you get a 50-50 deadlock, the company is paralyzed. So any receivership, the receiver's powers are set forth in the order that appoints the receiver. So what you can do depends on what the judge decides you can do. Now, a lot of judges don't always appoint receivers. And so if there's a motion to appoint a receiver, if one side is requesting me, I will offer some suggestions as to what ought to be in the receivership order. But typically what you try to do in a business receivership is you don't want to make any huge strategic decisions, although you do want the authority to make them if you have to. Typically, you just kind of want to put a lid on everything while the litigants sort it out.
Okay. And in that deadlock situation, are you working typically closely with the top tier folks that are or were running the company and have reached this problem, this deadlock?
Well, okay. So if you're talking about a situation where you've got a small company, a closely held company that's only got two shareholders and they're the ones that are actually operating the company, you really try to stay above the fray as the receiver, but that's really, really hard to do. So you wind up looking at what the fights are about and doing your best to just maintain the status quo as best you can. Sometimes that's hard. Sometimes one side is right and the other side is not right. That happens. And in that instance, you have to keep in mind, though, that your fiduciary obligation goes to the company and that you work for the judge. So that's my answer to your question. Do I choose one side or the other? Well, not really, but having done this for 25 years, you figure out pretty quickly that party A has got a better idea of what's going on than party B, and you do your best to preserve the value so that they can continue to fight about something. If you mess it up, there's nothing to fight about.
What's the third type of receivership you see?
Well, the third type of receivership is the coolest one, of course. That's what I do typically a lot of. Those are equity receiverships, typically in federal court actions brought by government agencies of some sort. Typically it's an enforcement action. It could be the Securities Exchange Commission. It could be the Consumer Financial Protection Bureau, the Federal Trade Commission, state attorneys general. They will file some kind of a lawsuit against a business entity or a group of individuals, charging them with operating some kind of a scam. It could be a pump and dump securities issue. It could be Section 5 issues for the FTC. It could be improper debt collection. It could be anything that violates some sort of federal or state law.
So those Section 5, when you say Section 5, and I think 13, which is like deceptive trade practices, things of that nature?
Yeah, those are consumer protection statutes. Section 5 of the FTC Act prescribes unfair and deceptive trade practices. And the FTC brings a lot of those. And
that's where I see you a lot and that's our first involvement when we cross paths. And typically in those cases, the AG, the FTC, they kind of combine forces and know what they're going to do before they let anybody else know it, but they bring you on board, right? I mean, you're part of the implementation of their lawsuit, right?
Well, yes and no. So the government agency will go ahead and get its case put together, and I have no input on that. They do all of the investigation. They write their complaints. They write their motions for TRO and the appointment of a receiver and all of that. I do typically get clued in ahead of the filing because, just the practical reason, I have to run a conflicts check. So I'll make sure that I or my firm do not represent anybody that's involved in the case. And then I'll get just a kind of a thumbnail sketch of what the case is about. When the case is then filed, there's typically a recommendation for, usually they give 3 names and then suggest one that they want in particular. And the judge will then make a decision as to whether or not to appoint a receiver. At that point, that's when I get the actual complaint and the supporting materials that go with it. And so that's when I get to see what it's really about.
Now, at this point, has the complaint been filed under seal so that the company that's going to be, I guess, a defendant, let's say for the FTC or the SEC, they don't know about this is coming, right? Typically. Well,
of course, right. You're right, and that's a good question. I mean, it wouldn't do very much good if you took out a press release and said, "I'm going to sue somebody and freeze all of their assets," before you did it. Good luck finding assets. It's just not going to happen. So yes, it is filed all under seal, including the appointment of the receiver. So there's a big secret going on. Then it takes me a few days to get organized, to get a team together to actually take possession of where the company is transacting business. Because one of the very important things that I have to do right off the bat is secure all of the records. Old school, the first few cases you and I did together, in fact, this is how old we are, I would actually take over a building, and the objective was to get all those paper records that were all over the place, because that's where everything was. It's now evolved, turned into electronic data on servers, and now it's all ESI stored on cloud servers. So, but that's important for me.
I know what happens, but many of the listeners and watchers of this don't. But you just walk in there and say, "Hey, I'm Mark Bernet. I'm the court-appointed receiver. Show me your records."
Well, it's actually a little more aggressive than that, because when I go in, I don't go by myself. I've usually got law enforcement, a lot of times the federal marshals. I'll tell you just a little war story. Sometimes we have some intel that the defendants may have concealed weapons permits or may have criminal records, violent criminal records or something like that. And in that case, I've actually gone into facilities with the marshals where they've made me put on a flak jacket. The very last,
I didn't sign up for this, Judge.
The very last case you and I did, though, there wasn't any of that kind of information, but still, I was working with the sheriffs. There were 7 of them. We went to the defendant's house. They all put on flak jackets, and then they had me go knock on the door to see if she would open up.
You're the canary in the coal mine.
I went first with no flak jacket. They put in the back.
I love it. There should be hazard pay for that.
Thanks, guys. It was turned into nothing, of course, but
you never know.
Safety first, right? Yeah, you go first. Okay.
Yeah. So the point, I guess I was trying to get to my listeners is that you often have to coordinate with law enforcement agencies, both state and federal, to coordinate, I guess, the execution or the implementation of the receivership order, right?
Yeah. Law enforcement has to come in. On top of that, anymore now, I need to bring in a forensics team, a computer forensics team, and I need to get them. Now, sometimes these cases, there's a grand jury lurking around in the background, or a U.S. attorney who's got some interest in it. And so there has to be a chain of custody kind of protocol put into place as well. So in those kinds of cases, the forensics team will actually be from the government, and we have to bring them in usually from Washington, although they're in other spots too. So all of this requires some coordination. You got to get your team put together before you go in, take control of the company, and then get at the records and the bank accounts. That's important.
You touch upon a really good point. I know I looked at your resume and looked back at the 2008 case that is listed on your resume. I think I still remember the name of the FTC prosecutor, Steve Cohen, I think might have been his name, but it was a seizure of a business somewhere in Pinellas Park, Florida, or Seminole, Florida, and old, documents and things of that nature. But as these cases have progressed and there's been more coordination, I guess, so that's my question. Have you seen greater coordination between the federal trade commissions, the SEC, the civil enforcement agencies, and the Department of Justice and law enforcement in parallel type of investigations and even prosecutions?
Yeah, there was an actual push within the FTC starting several years ago. The CFPB has been doing it too. They actually had an office with the FTC that was a liaison to U.S. attorneys' offices. And so I've had several cases where the U.S. attorney himself or herself would not actually come down to the immediate access day, but they would send postal inspectors, or occasionally even an FBI agent would come, and they'd be part of the team. And then when they're there, I just kind of let them do all of the chain of custody stuff. That way, if it's messed up, it's not my fault.
Yeah, I mean, and you know that back in 2012, I was involved in an FTC case that ultimately resulted in a rather large white-collar credit card laundering indictment out of the Southern District of New York, and really surprised, I guess, a little bit surprised, maybe not so much surprised, but that from 2012, when the FTC case kind of resolved itself with a stipulated judgment, that here we come to 2018 and 19, and folks in that FTC action are getting indicted.
They were recidivists, were they not? Hadn't they been involved in other earlier enforcement actions?
I believe there was a lot of recidivism and similar conduct that had to do with setting up sham merchant accounts and things of that nature. But I guess my point is, when you come in, you now are probably more aware of this becoming a potential criminal case also, right?
Well, yeah, yes and no. But see, now, when I was younger and I'd get into some of these cases, I'd actually get a little more fired up about them and think that this is just wrong. They're ripping off old people and whatnot. And my efforts at lobbying law enforcement went absolutely nowhere. And I just pretty much quit doing it after the first couple of cases that I did, just because they have their own parameters, the government, in terms of what they're going to prosecute criminally, and there's no point in pushing that. But after there was it was the FTC that started it, a liaison with U.S. attorneys' offices in particular. There seemed to be an increased emphasis on it, and so now, one of the very first questions I ask when they ask if I'm be available to handle a receivership is there a grand jury? Have we got a U.S. attorney that's been interested in this? Because it's become more common.
Yeah, I mean, that pendulum swung really far, to the extent, I think you're right, that now it's almost as if you got to, as far as from a defense attorney standpoint, when you're coming into these civil FTC or SEC or CPBD cases or AG cases, I think if a defense attorney comes in and is not keeping at least one eye aware of probably an invisible, if not visible, parallel investigation, I think that is, a rookie type of error now. I think you got to be aware of that.
Well, you make a very good point, which is one of the reasons I enjoy working with you. You've got enough background and experience that you're not going to ask. You never point blank ask me, is there a grand jury out there? And if you did, I'd just smile at you and say, I can't say. But you know that they can be and sometimes are. And so I know that information is getting conveyed to the defendant. And whether they get indicted or not is really not my concern. But having a defendant who understands all of the moving pieces that are going on here, that's important. They need to know all of that. And it affects, I assume you'll agree with me, it affects the litigation strategy and the civil enforcement action. If there's the possibility of a U.S. attorney lurking in the background there, you definitely think about that.
Absolutely, because from a defense attorney standpoint, it certainly could shortcut the civil litigation. And if you know your client or clients are the defendants and going to be potentially and are targets or unindicted co-conspirators, it could affect your counsel to them, certainly, because I know you like to get out in front of the ball and start taking depositions quickly to find out all kinds of information about asset location and folks that have gotten payments for certain things to try to maybe claw back assets. So and you typically get out ahead in front of the agency, that in my experience.
Well, so part of the job of a federal equity receiver, which is a third kind of receivership, is assuming that there's a conclusion that the business cannot be operated legally and profitably. That's the legal standard. Then it becomes an issue of shutting it down and trying to find out where all the assets went, or where did all the money go that this scam generated, and trying to bring it back in. So yes, that's equally as important as securing the records. I have to start trying to find assets. And you're right. I do start early on. The quicker you start, the less time there is for the things to disappear.
I mean, the folks listening need to understand that you are an extension of the court, right? I mean, you answer to the judge.
Yeah, I don't work for the government. I don't work for the defendants. I don't work for the government. I've had several cases where everybody's mad at me, which I figure is good, because I have to look at the interests of the court and of the generic entity. That creates actually, and I shouldn't be interviewing you, but I do want to bring it up because it's actually an issue right now in a case that I've got. Dual representation by the defense attorney of the individuals who are charged with operating the scam and their companies. Because once the receiver is appointed, there is a wedge between the two of them.
You stand in the shoes of the company. You are the company, right?
I'm the company now. I speak for the company, not the principals anymore. Which it's an awkward spot for me, because technically now I'm being sued by the government. I resolved this by saying that, look, the company's interests are mine to determine. I operate the company. I alone speak for the companies, except for this litigation. So, Mr. Eckard, you can have the companies if you want to try to run a defense to the government enforcement action. But other than that, I'm in charge.
And you're in charge, and you control potentially privilege and waiver of privilege, right, for the company.
That comes up a lot, especially on those first day issues. When I first go into the companies, I have to be everywhere because there'll be attorneys who've been involved and given opinions and provided legal advice. And so I have to be involved with all that. I can make a determination to waive that privilege for the company, not for the individuals.
Sure.
But sometimes, it's the rare company and principal who've been sued in an enforcement action who have put up strict lines between the individuals and the companies. It just always all gets mushed together. So,
all right. So you're in now as the receiver. You're marshaling assets. You may be sending subpoenas out for further information to third parties. During this process, you're doing your thing. The Federal Trade Commission or the government agencies doing their thing, pursuing what an ultimate civil litigation remedy would be, which would be a judgment of some sort.
Right.
And given the time remaining today, but even if the government agency gets their judgment, your job is not over, correct?
Right. Again, I'm working for the judge. I'm not working for the government. They can get their judgment, but the asset liquidation, finding them and then liquidating them can continue for quite a while after the enforcement part of the lawsuit is done.
I'm often out of the case, usually right around the time the judgment is stipulated to and agreed to or obtained, but I still get the CMECF court bounces in some of the cases, and I just shake my head sometimes thinking Mark is still in this case. And one in particular, a case, the Guillermo case, where there was a bankruptcy and there was a building, the client apparently lied about assets. That case seems to have a life of its own, and you're still in it.
That guy, yeah. Mr. Guerrero got sued by the FTC in 2018, I think, for running some kind of a credit card scam. He had filed bankruptcy back in 2011. And when you file bankruptcy, you have to fill out schedules that list all of your assets. Well, he kind of forgot he owned a tenement building in the Bronx worth about $3.5 million. The reason he forgot, of course, is that if he put it down, the bankruptcy trustee would take it and he wouldn't have it anymore. So he just kind of forgot. Yes, that is a crime. He got caught 8 years later for not having scheduled that. And so now there's a big row going on in the bankruptcy court from his failure to schedule assets 8 years ago, or now 12 years ago. So yeah, that one.
So are you essentially adverse to the trustee because you are trying to collect assets for, say, or for consumer distribution purposes, and the bankruptcy court wants it arguably for creditors, right?
Yeah, and the unfortunate result in that case is that the trustee wins because their right to that tenement building derived from 2012. Mine didn't arise until 2018. So at the end of the day, I'll get something out of it. But yeah, Mr. Guerrero is I've never seen that before. I've never seen anybody forget they owned a $3.5 million building.
I've seen it more than you think. This dovetails into like a payment. How do you get paid? How do you get paid for doing this once you're a receiver?
Well, so a receiver can get paid when the court says the receiver can get paid. So what you do as the receiver is you file an application for payment. Receiverships are equity. They're purely an equitable proceeding when the receiver is going on. So let me just tell you, all you practitioners out there is no such thing as a motion for attorney's fees in a receivership, or in a lot of instances. It is an application because you are in equity. You file an application for payment, and then you have to list all of the time that you worked, all of the things that you did, and what your hourly rate is, and then give it to the court and ask the court to authorize payment. I only get paid from the assets that I've collected. So if I have a case like the last one you and I have done, where, as it turns out, there were no assets, then I get a goose egg. That doesn't happen very often at all.
And of course, let me make a point here. Sometimes the government doesn't care necessarily. They hope there's going to be assets to recover, but I mean, they file lawsuits and seek these TROs with the idea to shut down the business with the hope there's going to be assets available, but there may not be, correct? I mean, the government has an objective, which is to shut the entity down.
Yeah. So I will say this, most of the agencies that I've worked for do some due diligence up front. And if it looks like an asset light case, they won't go for a receiver. So they typically try not to get me going where there's not going to be assets to pay. Sometimes it just doesn't work out, but usually that's rare. That's rare that happens. Usually it doesn't.
With a couple of minutes we have remaining, can you just briefly touch upon the difference between a receivership and a monitor?
Yeah, that's actually kind of a timely topic. We have a monitor appointed in the Trump business fraud case that's going on in New York. Monitor is different than a receiver. The monitor is appointed, just like it sounds, to monitor a company. You see this a lot of times in criminal actions where a company gets indicted or is charged or is threatened with being charged for committing some sort of a crime. The workout frequently involves a monitor going into the company and monitoring what the company is doing, monitoring its performance. If the allegation, for example, were some kind of a securities company doing some sort of pump and dump scam, then the monitor would go in and monitor how sales practices are going with the company. The monitor files reports with the judge. Depending on what those reports say, the monitor just continues to monitor. Or if there are problems with the performance, the judge can take further action. It can convert it to a receivership. It could be a violation of an agreement with the U.S. attorney, which could lead to criminal charges, things like that. That's what a monitor does. The receiver's a whole different thing. I know we're running out of time. Real quick, a receiver is a whole different thing. Receiver comes in, receiver's in charge.
Sure. And it sounds to me like if you're a private business, you don't want either one of those scenarios in your life.
You don't want either one. A monitor, the company has to pay for, and they're not cheap. Whereas a receiver, well, of course, you're out if you're the owner of the company and the receiver comes in. So no, you don't want either one.
In the last minute or two, do you have any tidbits of wisdom for all of the lawyers out there or the people that are interested in this topic? Anything that you want to leave them with before we close?
If you're involved in a case where a receiver has been appointed, cooperate with the receiver. Don't try to fight the receiver. Bear in mind, the receiver is not your opponent. The other side of the litigation that's not who the receiver works for. As Rob said, the receiver works for the court. And we try very hard not to take sides. Like I said, sometimes it's hard not to take sides if one side is just out to lunch. But we try to be fair about things. So cooperate. Don't get on the receiver's bad side because you won't give up, the financial records or
and it's likely the judge is going to know about it at some point.
Listen, once the receiver is appointed, if the receiver files any kind of a reasonable request with the court, almost always the judge is going to do it because, again, it's equity. I mean, there are no rules. It's just equity. What feels good? Now, I'm overstating it, of course, but yeah, the judge will back up the receiver almost always.
Well, I wish I would have been able to be a lawyer 25 years ago and listen to this podcast with you. Then I might have done things differently. But you've been a professional, and all my encounters with you and experience with you are top notch. You encompass and enlist folks that help work your receivership estate and experts, and you do so, at the best ability to minimize costs to the receivership estate. I've seen you do that kind of thing. So thanks for being here today. And I really appreciate this. And I really, the folks that are interested in this type of litigation and how it occurs, how would they best get in touch with you, Mark?
I'm with Akerman, and I'm in the Tampa office. Last name Bernet is up on the screen, Bernet. And you can find me there. You can call Rob. Rob's got my number.
And Mark often speaks and lectures to different bar symposiums on the topic. So we thank him for his time today. And we wish him success, and we hope to see you soon.
Rob, I really appreciate the opportunity to chat with you. This was fun.
Thanks, Mark.
All right.
Take care.
You've been tuning into Time is Not on Your Side with your host, board-certified litigation attorney, Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.